Yes.
for the rule in that case.
Yes,
What
ma'am.
is obiter dictum?
Well, it is just cited the case, but it does not decide the case. It's outside of the...
It's also persuasive, but it is not as significant or as vital as the ratio decidendi, right?
Correct.
So we are taught in law school, when you cite a case, cite the ratio decidendi of that case. Do not cite the obiter dicta of that case. Because obiter dictum is just like saying in plain English, by the way. Di ba?
Yes, yes.
Oh, ngayon, patunayan mo sa akin, ratio decidendi, di ba, ang binigay mo doon sa kaso ng salvation, China banking, and ejercito, that the prosecution cited as its cases so that the foreign currency deposits of the defendant should be opened. Yan ang desisyon mo eh. Yun ang argumento mo eh. Inutos na yan o ng Korte Suprema, di sundin natin. But were you citing the ratio decidendi or not?
If I may explain, can I explain?
Please
Your
explain
Honor.
as short as possible because,
Okay.
you know,
We cited that case because that was one of the instances wherein the Supreme Court
hindi mo ni-cite ang
made
ratio decidendi
an
na.
exception.
If you had cited a ratio decidendi, sasagot ka ngayon sa akin ng oo. May paliwanag ka pa eh. Ngayon sa salvation, kamo kanina, judicial precedent applies when the facts are the same, right? All right, answer this one question. In the case of salvation, where the Supreme Court ruled that the foreign currency deposit could be scrutinized, what was the main offense charged?
It was rape, Your Honor,
Right.
by a
Is
foreigner
rape
of
by any stretch
child,
of the imagination
Filipina.
the same as impeachment? Do not answer the question. China banking. Dito sa China banking naman, the Supreme Court ruled, quote, in view of the distractive, meaning to say distracts the attention, circumstances attendant to the present case were constrained to render a limited pro hac vice ruling. What is the meaning, counsel, of pro hac vice?
Only in this case, applicable only in this case.
Yun lang pala eh. Alam mo naman pala eh. Alam mo pala na doon sa China banking, the Supreme Court said, this ruling applies only in this case, and yet you cited it in this case. Ikaw naman, oo. Next, ejercito exception. The third dollar deposit case is ejercito versus Sandigan. Remember you replied to me earlier? You said, we can cite the doctrine of judicial precedent if the facts are the same. Now, in ejercito, what was the offense there? Do you remember?
Yeah, it was the officials, the
plunder.
ombudsman. Yeah, the
It was
officials of the
plunder.
ombudsman. Plunder,
All right.
yes.
This is an impeachment case for betrayal of public trust, etc. Which is the case for plunder? No. Yan. Di nakita mo na. Iba-iba pa lang mga pinagsasabi mo eh. Ngayon, Inklings. Inklings case, you did not cite in our debate on foreign currency. In Inklings, the Supreme Court ruled, under RA number 6426, there is only a single exception to the secrecy of foreign currency deposits. That is, disclosure is allowed only upon the written permission of the depositor. What was the subject matter of the case? Inklings.
We did not cite that, Your Honor.
Foreign currency
Foreign
deposits.
currency, yes.
Exactly. So
Yes.
there's only one case on record, which is on all fours with the facts of this case in the impeachment court. All your three other cases are absolutely irrelevant and you cannot cite them as judicial precedent. Ngayon, bilisan ko na lang ito. Ito. The rules of court provide for disputable presumptions. These are presumptions which are satisfactory if uncontradicted, but they may be contradicted and overcome by other evidence. That is why they are called disputable. The presumption is in favor of one party, but the other party might produce evidence, then the presumption no longer holds. One disputable presumption is that evidence willfully suppressed is evidence adverse, would be adverse if produced. According to a long line of cases, this presumption applies only if the suppression is an exercise of a privilege. In other words, if it does not lie within the discretion alone of the defendant, but is related to some national interest, then the presumption does not apply. For example, yung itong pagsasagot sa pagtatanong, kung wala siyang tinatago, ba't hindi niya ipalabas? Yan ang sagot sa batas. Because he's not allowed to do that by law. It doesn't fall exactly on his personal discretion alone. For example, It is reported that when one bank official testified against President Estrada in his impeachment case, her testimony was followed by massive withdrawals from her own bank. That is a fact. It is discussed sub rosa secretly by the banking community dahil takot na takot sila sa bank run. Yan ang nangyari. Merong isang opisyal pumunta dito, dinaldal niya lahat tungkol sa kaso ng akusado noon, kaya lahat ng depositors nila nag-withdraw. Now, my question to you is, what is your guarantee that insisting on testimony from bank officials will not be followed by a bank run?
Because this is impeachment, Your Honor. And we are only asking this because of the impeachment proceeding. And responding to the Chief Justice.
In other words, you have no guarantee, right? Pwede mo ba garantiya na hindi ito ma-follow ng bank run pag pinilit natin umupo yung opisyal doon, hala, daldal siya ng daldal tungkol sa pera?
With due respect, Your Honor, there are only few officials who are subject of impeachment. And our argument is that this should be one of the exceptions to this
yun ang mahirap.
Foreign Currency Deposit
Yung
Act.
mga exception na yan. Ngayon, nagmamadali lang kasi ako, pasensya ka na. Under the rules of evidence, a witness is entitled to certain rights. Hindi naman sukat umupo siya dyan, pwede mong gawin ang gusto mo. One of these is, quote, I'm quoting from the rules of court, not to give an answer which will tend to subject him to a penalty for an offense unless otherwise provided by law. Under the Foreign Currency Deposits Law, if the bank president refuses to answer a question concerning a foreign currency deposit, will he incur a penalty?
If there's a justifying circumstance, then he will not incur.
You're temporizing. I give you a grade of 3. In UP, as you know, that means 3 warning. I pass you, but I warn you.
Thank you.
Question 7. On the one hand, the Paris Task Force of the International Anti-Money Laundering Treaty tries to pressure every government to open all its bank deposits to the public. Dahil yun ang kanilang mission in life to avoid people from hiding illegal wealth in bank deposits. But on the other hand, those in favor of bank secrecy argue that no one will deposit his money in any bank unless confidentiality is guaranteed. Ilalagay ba natin pera natin sa bangko kung hindi tayo sigurado na sikreto yan at hindi niya ibabalita sa madla? Many business leaders fear that if this impeachment trial opens bank records, then the depositors will transfer their deposits to stricter countries like Switzerland. I've already said Switzerland is now gaining a reputation. Singapore is now gaining a reputation as the new Switzerland of the world because they have such strict laws about bank secrecy. They will never reveal. It takes a very, very complicated legal procedure. So, kung ganyan pala, lalagay mo pera mo sa bangko, pwede palang iladlad, how do you say in Tagalog? Pwede palang iladlad yan ng kung sinong opisyal dyan sa bangko. Abay, kukunin ko pera ko, ilagay ko doon sa bangko na hindi niya ibabalita sa buong mundo ang pera ko. So, question, is the prosecution panel willing to assume responsibility for substantial hardship on the Philippine banking industry? I will educate you as part of my prerogatives as a judge that is the present concern of the Makati business community.
Your Honor, we believe that the public policy here is public policy of accountability and transparency. And the impeachment proceeding of the Chief Judge should be an exception to that. It is only an exception. And hindi ho kasama dyan yung bank run, kundi isang tao lang po ito, at ito'y Chief Justice na kailangan natin buksan ang kanyang bank accounts.
Pag nakinig ang mga taga-TV at mga radyo, iba pa dito sa gallery, baka magiging ganon ang resulta. I heard that bell, maybe it's intended for me. May I just have permission to read one last question?
Before that, Your Honor, just can I just say something?
No, because you're taking up my time. Okay. Ask him. On the one hand, it is argued that absolute confidentiality of foreign currency deposit will attract non-resident depositors. Kaya tayo pumasa ng batas na iyan na hindi pwedeng sabihin ang maski ano tungkol sa foreign currency deposit para yung mga dayuhan pupunta sa Pilipinas at ilagay nila pera nila dito. Ngayon, kung bubuksan natin iyan, hindi na sila pupunta dito. Pupunta na sila sa Singapore, iba pang mga bansa. But on the one hand, it is now argued that foreign currency deposits might become a haven for the ill-gotten wealth of crooks, terrorists, and other criminals. Abay, kung ganyan pala na hindi pala mabuksan-buksan yung mga foreign currency, ay tayong mga, how do you say, nangungurakot sa gobyerno, dito natin ilagay pera natin, wag na sa peso deposit, dito na sa foreign currency, dahil safe tayo doon.
May I request the lady to wind up?
Yes, I am winding up. Insofar as Filipino crooks and criminals are concerned, would you be willing to file an amendment to the foreign currency secrecy law to provide the proper exception, allowing the scrutiny of foreign currency deposits only when the Filipino citizen is depositor? Because if you allow public scrutiny for all kinds of depositors, foreign depositors will naturally no longer deposit their money. O ngayon kung habol lang natin ay yung mga nagnanakaw sa gobyerno, gusto mo bang i-amend ang batas na ang mga Pilipino pwedeng suriin, pero ang dayuhan hindi? Na question. If so, how would you then answer the issue of discrimination against Filipinos in their own country?
Una sa lahat, Your Honor, willing tayo mag-file nun given yung nangyari ngayon sa Korte Suprema. Because we thought na yung mga whereas clauses ng Republic Acts regarding the Foreign Currency Deposit Act and the Bank Secrecy Law, akala natin yung whereas clauses ay para lang yon yung public policies, para dun sa foreign depositors, lenders, and investors. So we are willing to file. And hindi ho madidiscriminate yan because there should be sufficient yung differentiation, yung distinction sufficiently, dapat mapakita lang natin na may distinction at hindi po madidiscriminate yung mga Filipinos. And we are thinking about that, Your Honor, because of this ruling of the Supreme Court.
All right. Majority Floor Leader.
Yes, Mr. President, we are ready for the cross-examination by the witness, by the defense, for the witness of the prosecution from the last time. So,
Is the witness subject to cross-examination around? I'm asking this from the prosecution.
Yes, we are not yet through with our direct examination with the witness from the PS Bank, the President,
PS
Mr. Pascual Garcia. But before that, Your Honor, just one.
Just a minute. If you're not through with the direct examination, are you ready this afternoon to present him for direct examination?
Yes, Your Honor, we're ready.
Then bring him into the courtroom.
Okay, we now call on our witness, Mr. Pascual Garcia, President of the PS Bank. And may we request, Your Honor, that Attorney Demetrio Custodio be recognized to conduct a direct examination for the prosecution.
While the witness is coming to the courtroom,
Yes.
session suspended for
may we request 15 minutes, Mr. President?
15 minutes.
The session's just been suspended, and that's so far been, I believe, the longest hour so far where the senator judges stood up to explain their votes on why they voted either to uphold the Supreme Court temporary restraining order on the foreign currency deposits of Chief Justice Corona, or on the other hand, explaining why they voted to open the bank accounts and not follow the Supreme Court TRO. Chief Justice Renato Corona has come out with a statement. He has issued a statement, and let me read you some main parts of this statement. We have online brought out the statement through ANC Alerts, the ABS-CBN news channel, but some main parts of the statement, Corona says to the prosecution team, I do know my law. I have not broken any law. I have no liability to the people and the government. You are seeing right now a part of the statement. He says, what my wife and I have is the fruit of hard and honest work for which all the taxes have been fully paid. Moving forward, he writes, you did not have any iota of evidence against me when you filed the impeachment complaint. And further on to the statement, the last part of the statement, Corona challenges, in effect, it's a message to President Aquino. He says, finally, the president has clearly committed an impeachable offense when he came out swinging by, openly urging the senator judges to disobey the Constitution. He has personally sworn to uphold. Itong impeachment trial na ito ay isang huwad, isang paghihiganti ng sukdulan at kahiyahiyang tangka na pigilin ang pagbabahagi ng lupain sa Hacienda Luisita. Corona was referring to the 15-0 vote of the Supreme Court ordering that at least, I think, was that close to 4,000 hectares of Hacienda Luisita be distributed to the farmers. So that was rather the official statement of Chief Justice Renato Corona. So, Adele, Linda, what was your take on it? I wanted to ask you, must be so difficult to actually be the prosecution when you have Senator Miriam Defensor Santiago not just asking clarificatory questions, Adele, but in a way lecturing you on national TV.
Before Adele answers that, I think it's difficult to be Neil Tupas.
Exactly.
Senator
Yes.
Miriam Santiago is
Linda.
before you. I think it's pretty clear that the senator has taken a liking to Congressman Tupas. But anyway, Adele.
Well, actually, Senator Miriam's point, one of her points, I think it was a good point, and I've discussed it already. The cases that were cited by the prosecution when they were asking for the issuance of subpoena, which was used as a basis for the issuance of a subpoena by the impeachment tribunal, really, well, off tangent. That's the language that Miriam used. In the Salvacion case, if you read it, it's very clear. This is not my words, this is the words of the Supreme Court. Just read the dispositive portion. It says that they find Republic Act 6426 inapplicable to the case at bar. So there was no exception. They said that the law on foreign currency deposits does not apply to this in this case because a foreign transient is not included within the ambit of that law. So that's Salvacion. China Trust Bank, again, Senator Miriam raised that point. It was correct that the Supreme Court said that that case was a pro hac vice case, only for that case. And the last case that was cited by the prosecution, the Ejército case, I've read it, I've reviewed it, and it referred more to a violation of Republic Act 1405 and not the law on foreign currency.
Yeah.
So she does have a point, and basically what she was asking, trying to get from Congressman Tupas, was an admission that, well,
Mali yung sinasite
Yeah,
nila, or at least it's not on all fours. It's not the
Yes.
applicable cases.
yes, the legal basis is incorrect.
Adele, Linda, in layman's terms, why don't you explain the words for the day, which is ratio decidency? Did I say
Decidendi.
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 Ratio decidendi.
Yes.
Okay.
Yeah. Well, ratio, usually that means the actual reason. Yeah, the rationale. That's why you have also the ratio legis, or the reason for the law. Ratio decidendi is the reason for the decision itself. That's essentially what it means. Because when you read a Supreme Court decision, there are a lot of things that are stated there.
Yeah.
And not everything refers to the ratio decidendi. There are some things that are known as obiter dicta, meaning that these are by the way statements, meaning that these do not have a direct relationship to the case, but they are not, as some may mistakenly believe, no? They are not unimportant. They may in fact be of persuasive effect. But when you cite a case using obiter dicta, that is incorrect. That does not apply.
Yeah.
And a judge could actually cite you for contempt if you are found to be misusing